Good morning, good morning, children. How are you? Okay, okay. You all are fine, I know. See, today the topic what we are going to discuss, children. Before going to that topic of legal studies, different topic what had been discussed by us. Any question you do have, you must ask. The topic like features of our judiciary, the attorney general or the advocate general, the independence or the different roles of Supreme Court, High Court, lower courts we have discussed. Fine. Now, today we are going to discuss in detail regarding the independence and impartiality of Indian judiciary. Yes, children. We know how impartial is our judicial setup. Fine. But what are the ways, what are the means, and how had our judiciary succeeded in achieving this status? What are the base or the foundation document for it? We are going to discuss all those things today in today's class. Fine, children? So, first, in this class today, we will try to understand how the independence of judiciary is ensured and maintained by our constitution, by the Indian constitution. Right, children? So, the base document is our constitution. Ins and outs, every minute detail of our functioning of every organs of government had been enshrined in our constitution. That's why we are finding it here that the proper understanding of our constitution is necessary because our constitution has given this status of independence of judiciary. And for this, one theory is there, children. That theory is known as theory of constituent mechanism. In this theory of constituent mechanism, and it is related with the independence of judiciary. This theory defines judiciary's independence in terms of the independence of its judges. Fine? Judges are independent in such a way, children, that once the committee or the collegium who appoints them by following a proper procedure, through the same procedure, they can't dismiss them from their post. It means, suppose a judge takes over his or her office. Somewhere judges must be having in his or her mind that okay, because of this government I had been appointed. But see, what does our system say? Judges are not supposed to think in that manner because this is the strength, inherent strength of our system, not one individual, not one political party, not from the side of one person this decision has been taken. This has been the decision of a system, and whosoever is being sworn in is getting this post of judges or of jury members because of our system, because the system we do have in our country, in the democratic nation, in democratic setup of India, anyone who gets elevated to that post because of the system, because of the inherent strength of a system. Fine, children? So, this mechanism, constituent mechanism, simply defines judiciary's independence in terms of the independence of its judges. Okay, and then what are the expectations from the judges? Judges ought to function in an unbiased manner. Unbiased manner is utmost important for judges to function. And because our system simply says that there is a rule of law in the judiciary, in the court believes only in the witnesses produced before them. Suppose court knows that okay, one person, one side is can be given a clean sheet, is not involved, but the opponent, another side, has produced enough evidence against first side, or whether it's the prosecution, whether it's the defense. Suppose prosecution fails in providing evidence and the defense, they had given the evidence, or prosecution had given enough evidence, defense couldn't furnish the evidence, but defense is in fact innocent. In that case also, because of lack of evidence, judges are bound to give their verdict in favor of the side who succeeds in presenting all the evidence before the jury members. That's why no question arises that judges won't function in an unbiased manner. Exceptions are there, and for that purpose, we do have a detailed procedure of impeachment of our judges also, children. In the next topic, we will discuss that impeachment of the judges. How are they being impeached? How can they be removed from their post? Okay, so judges must function in an unbiased manner, undoubtedly, and scholars, as pointed out by Simon's retreat, and in the culture of judicial independence and judges on trial, it has been written in detail that why and how every jury members, they must function, they ought to function, and we are having enough expectations from the jury members to function in an unbiased manner. Fine. So, what can be noted? What one must note, that independence of judiciary and impartiality of judges. Independence of judiciary and impartiality of judges exist as two distinct concepts. These are not two similar concepts, these are two distinct concepts, where the independence of judiciary simply refers to the institution, and impartiality of judges refers to its constituent actor. Okay, you just try to understand it. That independence of judiciary means here we are referring to the institution. Fine. The institution of judiciary. And as far as impartiality of judges are concerned, so judges are the jury members, are the actors, they are the constituent actors, isn't it? So these are the two different concepts, where independence of judiciary refers to the institution, the impartiality of judges refers to its constituent actors, and this concept of impartiality of judges can be well understood within the broad framework of independence of judiciary. Now, actor is acting within the framework of the institution, within the framework of the independence of judiciary. So these concepts must be discussed, must be understood, must be studied in conjunction, together, as they aim at achieving the same goal of maintaining judicial integrity. Our purpose is to maintain the judicial integrity. Okay, so for the purpose of maintaining the judicial integrity in the democratic process of our country, in the world's largest democracy, you can say. Fine? Any confusion? So, in conjunction, in totality, these concepts need to be understood, need to be studied, need to be discussed, because they do have the same goal: judicial, to maintain judicial integrity. Okay, and we know our country does have the tag of world's largest democracy, isn't it? Simultaneously, what we need to discuss, the constitutional framework for the independence of judiciary, we also need to discuss. So the Indian Constitution contains several provisions. These twin functions are being served and our constitution contains several provisions to serve these twin functions of independence of Indian judiciary and impartiality of Indian judiciary. Okay, children? Now, come to provisions relating to the institution of judiciary. Here, another thing you must keep in mind that recently the former Chief Justice of India, Mr. Ranjan Gogoi, has been nominated as a member of Rajya Sabha, and there has been huge uproar. Okay, enough critics were there, criticism were there. Why did it happen? He must not have accepted all these posts. But the thing is, the judges, they are also independent after retirement, and if one gets such post, he also tried to justify it. He told that let me be sworn in first, then I will be replying, I will be giving the reply to each and everyone. And he told, in an interview, he told that see, everybody is free to think whatsoever is genuine for me, whatsoever I feel that the verdicts given by me has been highly in an impartial manner, in an unbiased manner. I gave it. I am fully satisfied, and anyone who wants to check it, they can do so. Not the responsibility I had been given, I will accept it. I will go ahead with it. Why will I say no? It's my personal decision, because I never compromised with my job profile. I knew my responsibility as the judge of Supreme Court or as the Chief Justice of India. Thereafter, if someone makes a hue and cry, let them do. Okay, questions people are free to ask, and I will participate in every debate and discussion taking place in my house in Rajya Sabha. Then people will see. Okay, so this is the level of impartiality of our Indian judiciary, children. Fine. In this constitutional framework, we will discuss here the provisions relating to institution of judiciary. Fine. Our constitution, Indian constitution, contains several provisions to serve these twin functions. And we do have two dedicated articles, children, Article 129 and Article 225. It's regarding the court of record. This court of record, you will see here that what is actually the court of record. Okay, so the Supreme Court cannot be, the Supreme Court of India cannot be curtailed by the Parliament. The Constitution had given enough powers to our courts, and Supreme Court can never be curtailed by the Parliament. Okay? In civil cases, children, Parliament only has a limited right. What limited right? In civil cases, to change the pecuniary limits, means the monetary limit. That pecuniary limit for appeal to the Supreme Court. Parliament has a limited right to change the pecuniary limit for appeal to the Supreme Court. This Parliament can do in case of a civil cases. And the Supreme Court has a vast appellate jurisdiction and supplementary powers to enable its efficient functioning. Supreme Court has a vast appellate jurisdiction and along with it enough supplementary powers to enable its efficient functioning. Means efficient functioning is the key. It must not be compromised with. Okay, children? And both the Supreme Court and the High Courts are courts of record, and it possesses the power to punish for contempt against the judiciary or judges. Contempt means any verdict had been given and it is not being followed. It is not being, their instructions are being overlooked. So in that case, they do have the right to punish them as well. That is the contempt of court. Maybe an institution, maybe the government, maybe an officer, maybe an individual, okay, including you and me. In case of a contempt of court, they do have the right to punish them. Here one term came, children, that is court of record. Supreme Court and High Courts are courts of record. Here you need to understand the court of record basically. A court of record is a trial court or appellate court. It may be a trial court or appellate court in which a record of the proceedings is captured and preserved for the possibility of appeal. Everything is being recorded there and kept so that if it goes to the higher level, then accordingly the verdict should be given by taking care all these previous instances. Fine. And the dedicated article in our constitution we do have for this court of record, children, it is article 129. Article 129 of our constitution says Supreme Court is a court of record. And simultaneously another article we do have, article 225, it says high courts are courts of record. Fine. So these article 129 and 225, in fact, children, they entitles, they empowers, they give this tag or status to Supreme Court and High Court. They make it court of record. Okay, now you can ask that, are all courts courts of record? No. So we need to understand also courts not of record. In courts not of record, what happens? In fact, oral proceedings are not recorded. Whatsoever proceedings, oral proceedings are going on, are not being recorded, and judge makes his or her decision based on notes and memory. On the basis of notes, on the basis of memory, judges makes his or her decision. It doesn't mean that the justice giving pattern or system is being compromised with there. No, not at all. Only difference is that the entire proceedings are not being recorded. What record we are finding in case of a Supreme Court and High Court. For example, the most small claim courts, most small claims court, traffic courts, justice courts presided over by the Justice of Peace, administrative tribunal courts, they are not the courts of record. They are, it means courts not of record. High Court, Supreme Court is court of record. Fine, children? Any confusion? Must ask, and to work sincerely. Must use this time what you are getting right now, thinking that you are going to appear board examination this year. Okay, children? Fine. Thank you. Have a good day. Take care.